So, good evening. I would just want to reiterate what I said last in my last video on writing about labor code. It's not the end. It's just the beginning. Always the beginning. So, that's it. We're now May 5, 2022, 1:16 a.m. and I'm still awake. I'm ready to conquer this chapter 2 of the Labor Code of the Philippines. So now, I'm reading this book. It's authored by J.G. Chan, the Labor Code of the Philippines, titled Volume 2, Labor Relations. So I started reading the codes 208 to 223. So we are now in 224, Article 224 to hopefully I can finish Article 228. Powers and Duties, Chapter 2, Article 224. So let's start now. By the way, this is a revised edition by year 2017 because there are some revisions on the code by the year 2016. So now let's read Chapter 2, Powers and Duties, Article 224, 217. Jurisdiction of the labor arbiters and the Commission. A. Except as otherwise provided under this code, the labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 days after the submission of the case by the parties for decision without extension, even in the absence of stenographic notes. The following cases involving all workers, whether agricultural or non-agricultural. Number 1. Unfair labor practices cases. 2. Termination disputes. 3. If accompanied with a claim for reinstatement, those cases that works may file involving wages, rates of pay, hours of work, and other terms and conditions of employment, claims for actual moral exemplary and other forms of damages arising from the employer-employee relations. Cases arising from any violation of Article 279, parenthesis 264 of this code, including questions involving the legality of strikes and lockouts, except claims for employees, compensation, social security, Medicare, and maternity benefits. All other claims arising from employer-employee relations, including those of persons in domestic or household service, involving an amount exceeding 5,000 pesos, regardless of whether accompanied with a claim for reinstatement. B. The Commission shall have exclusive appellate jurisdiction over all cases decided by labor arbiters. C. Cases arising from the interpretation or implementation of collective bargaining agreements and those arising from the interpretation or enforcement of company personnel policies shall be disposed of by the labor arbiter by referring the same to the grievance machinery and voluntary arbitration as may be provided in said agreements. Notes and comments. Introduction. Need for a comprehensive discussion of jurisdictions of various labor authorities under this code. The discussion under this code is divided into 4 parts to it. Part 1. Jurisdiction of labor arbiters. Part 2. Jurisdiction of the Commission and LRC. Part 3. Jurisdiction of DOLE regional directors. And Part 4. Jurisdiction of DOLE secretary. While Article 224.217 clearly enunciates only the jurisdictions of the labor arbiters and the commissions, there is a need to include herein a discussion on the respective jurisdictions of the DOLE regional directors and the DOLE secretary in the light of the following justifications. While normally the decisions of the DOLE regional directors are appealable to the DOLE secretary, the former being the settled authorized representatives. Number 1 pa. Of the latter in the DOLE regional offices, the decisions of the DOLE regional directors in simple or small money claims are appealable in the NLRC Confusion continues to exist as to the distinctions between the jurisdiction of labor arbiters and the regional directors, and there is no single definite provision in the labor code or in any other issuance where there is comprehensive and holistic discussion of the jurisdictions of these labor authorities. Ganito. Ganito kakapal yung kailangan ko basahin. From Article 228, from Article 224 to Article 228. So guys, tingnan mo naman. Sobrang almost an inch. 1 inch na babasahin. Grabe. Hirap. Mahirap nga talaga pag abogado guys. So, let's continue down with the reading. Hindi pwede magreklamo kasi gusto mag-abogado. Okay. Notes and comments. Introduction. Number 1. Need for a comprehensive discussion of jurisdictions of various labor authorities under this section. The discussion under this section is divided into 4 parts. To it, Part 1. Jurisdiction of labor arbiters. Part 2. Jurisdiction of the Commission and LRC. Part 3. Jurisdiction of DOLE, Regional Directors. Part 4. Jurisdiction of DOLE, Secretary. Well, Article 224, 217 clearly states Article 224 clearly enunciates only the jurisdictions. Wait, I'm just googling something. Wait. So guys, I divided the article, the pages to kung 125 pages lang ako, okay na. So let's start. Need for comprehensive discussion of jurisdictions of various labor authorities under this section. Part 1, Jurisdiction of Labor Arbiters. Part 2, Jurisdiction of Arbitration. Part 3, Jurisdiction of Dulles Regional Directors. And Part 4, Jurisdiction of Dulles Accounting. While Article 217 clearly enunciates only the jurisdictions of the Labor Arbiters Commission, there is a need to include herein a discussion of this. The Regional Directors in the light of the following justifications, while normally the decisions of the Dole Regional Directors are appealable to Dole central authorized representatives of their regional officer's decision of the Dole Regional Directors. Small money claims are appealable to them. Continues to exist as to the distinctions between the jurisdiction of labor arbiters and the regional directors. Definitive provision in the labor code or in any other issues. Comprehensive and holistic discussion of the jurisdiction. This one has to be very conversant labyrinthine articles of the labor code in order to determine for himself the various is falling under the respective jurisdictions. For instance, even if Article 224 entitled jurisdiction. It is a fact, however, that this is not it's just so it's the cases fall under arbiter and the commission, and while this article in its paragraph B mentions only the appellate jurisdiction of the commission vis-a-vis the decisions, orders, or awards of the labor arbiter, there is another provision of the labor appeal to the NRS from another agency for greater clarity. House references to the various articles of the labor relevant to the jurisdictions of the foregoing officials on the discussion below. Note the proceedings before the labor arbiters and the NLRC are extensively discussed in the notes and comments. 217 under the following topics: proceedings for the labor arbiters, and 6 proceeding for the commission and RC. Topical presentation. Let's discuss that with the experts. Part 1, jurisdiction. Personal arbitration. Money claims, jurisdiction over claims for damages, jurisdiction over legality of strikes and lockouts, jurisdiction over cases involving legislative mainstream cases and wage distortion, jurisdiction over contested cases under the exception clause in Article 128B of the Labor Code, jurisdiction over enforcement or annulment of compromise agreements, jurisdiction over enforcement decisions of voluntary arbitrators, jurisdiction over OW cases, Other issues over which labor arbiters have jurisdiction. Issues and cases over which labor arbiters have no jurisdiction. Part 2. Jurisdiction of the Commission. Part 3. Jurisdiction of DOLE Regional Directors. Part 4. Jurisdiction of DOLE Secretary. 1. Original jurisdiction of the DOLE Secretary. 2. Appellate jurisdiction of the DOLE Secretary. 3. Rule 65 Certiorari Petition, the only mode of elevating a case from DOLE Secretary to Court of Appeals. Rule 45 Petition for review on certiorari to the Supreme Court from decision of the CA. Part 1. Jurisdiction of labor arbiters. 1. Historical context. Court of Industrial Relations. The first one-man labor code in the Philippines, the Court of Industrial Relations, CIR, was created with the enactment of Commonwealth Act No. 103 on October 29, 1936. It had jurisdiction over the entire Philippines to investigate. It had jurisdiction, Court of Industrial Relations, to investigate, consider, decide, and settle any question, matter, controversy, and dispute. Question, matter, or dispute arising between affecting employers and employees, and regulated the relations between them. Later, the Court of Industrial Relations was converted into a horizontal post of senior judge, and two others was further enlarged into a 5-woman court, and its jurisdiction was amplified to cover landlord and tenant relations. 5-woman court. Landlord 461. The jurisdiction of the Court of Industrial Relations was either expanded or reduced with the enactment of such laws as the 8-hour labor law, minimum wage law, the Industrial Peace Act, the Agricultural Tenancy Act, the statute creating the Court of Agrarian Relations, and the Agricultural Ad Hoc, No. 2 Ad Hoc NLRC, because of the widespread disenchantment. Ad Hoc NLRC No. 2. Because of the widespread disenchantment with the performance of the CIR, an Ad Hoc NLRC attached to the Department of Labor Ad Hoc NLRC because of the widespread disenchantment with the performance of the CIR. An Ad Hoc NLRC attached to the Department of Labor and Employment was created under PD number 21. It was composed of the Undersecretary of Labor or his duly authorized representative as chairman, and the Director of Labor Relations and the Director of Labor Standards or their duly authorized representatives as members. It had original exclusive jurisdiction over the following cases. Number 1. All matters involving employer-employee relationship, including disputes and grievances which may otherwise lead to strikes and lockouts under RA number 857, all strikes overtaken by Proclamation number 1081 of martial law and all pending cases of the BLR. Number 3, the labor arbiters and the NLRC under the Labor Code. The ad hoc NLRC under PD number 21 was enshrined in the Labor Code with the issuance of PD number 1242. Its jurisdiction was further broadened by vesting upon the labor arbiters and the NLRC exclusive jurisdiction to hear all other cases arising from employer-employee relations unless expressly excluded by this labor code. Unlike the jurisdiction of the CIR, which was described as a special court partaking of the nature of an administrative board vested with executive and judicial functions, the jurisdiction of the NLRC under the Labor Code, which was described as having the character of an administrative board partaking of the nature of a special labor tribunal, was far more expanded, while the jurisdiction of the CIR was limited to unfair labor practice cases, representation cases, and national interest cases. The jurisdiction of the NLRC included all cases involving employer-employee relations. Number 4, amendments to Article 224. Among the provisions of the Labor Code, Article 224 is one of the frequently amended provisions. It has been amended by a number of laws, namely PD number 1367, PD number 1691, BP bilang 13 Batas Pambansa bilang 130, Batas Pambansa bilang 1227, and RA number 6715, whose amendatory provisions are the ones reflected in the current article. Batas Pambansa. Compulsory arbitration. Definition: compulsory arbitration is a mode of resolving a dispute whereby the consent of one of the parties is enforced by virtue of the law and following certain procedure laid down by law. In labor cases, it is a process of adjudicating and settling of labor disputes by a government agency which has the authority to investigate and to make an award which is binding on all the parties. It is a system whereby the parties to a dispute are compelled by the government to forego their right to strike and are compelled to accept the resolution of their dispute through arbitration by a third party. Example is a case filed before the NLRC which is heard by a labor arbiter who is chosen through the process of raffle or other modes where the parties are not afforded to the right to voluntarily and freely choose the person of the labor arbiter who will hear and decide their cases. The essence of arbitration remains since its resolution of the dispute is arrived at by resort to a disinterested third party whose decision is final and binding on the parties. But in compulsory arbitration, such a third party is normally appointed by the government. Number 2, historical perspective. Compulsory arbitration has been an accepted mode of resolving labor disputes in the Philippines. The 1935 Constitution explicitly established a regime of compulsory arbitration when it expressly provided that the state shall afford protection to labor, especially to working women and minors, and shall regulate the relations between landowner and tenant, and between labor and capital in industry and agriculture. The state may provide for compulsory arbitration. To implement this constitutional precept, the CIR was created by virtue of Commonwealth Act No. 103, enacted by the National Assembly in October 1936. More specifically, the CIR was empowered to enforce compulsory arbitration between employers or landlords and employees or tenants, respectively. It had jurisdiction to consider, investigate, decide, and settle all questions, matters, controversies, or disputes arising between employers and employees, landlords and tenants, or farm laborers, and regulate their relations. Under Section 9, Article 2 of the 1973 Constitution, the same phrase mandating that the state may provide for compulsory arbitration was replicated. Consequently, the compulsory arbitration regime continued to be observed. The CIR was replaced by the NLRC and the labor arbiters. the cases pending in the CIR as well as its unexpended funds, properties, and records were transferred to the NLRC. While the CIR was characterized as a special court which partakes of the nature of an administrative body possessed of executive and judicial functions, the NLRC is described as an administrative board which partakes of the character of a special labor tribunal. The NLRC, even before the promulgation of the Labor Code on May 1, 1974, was already being granted jurisdiction to conduct arbitration and adjudication of claims arising from employer-employee relationship. In fact, the Supreme Court had declared that the only claims arising from employer-employee relationship which were beyond the jurisdiction of the NLRC were those already pending in courts on or before September 21, 1972. Beside the NLRC, there was a provision in the Labor Code, Article 220, granting the power to the NLRC or any labor arbiter to seek the assistance of other government officials and qualified private citizens to act as compulsory arbitrators on cases referred to them. This provision of the Labor Code, however, was completely repealed by Section 16 of Batas Pambansa bilang 130, absence of provision on compulsory arbitration in the 1987 Constitution. Although no similar provision on compulsory arbitration is found in the 1987 Constitution, this does not mean, however, that compulsory arbitration is a mode of settling labor disputes has been completely abandoned. According to one of its framers, compulsory arbitration was not ruled out in the 1987 Constitution. It was merely downplayed. The omission to expressly provide for compulsory arbitration in the 1987 Constitution should be construed to stress the importance and significance ascribed by the framers thereof to voluntary modes of settling disputes and collective bargaining. Compulsory arbitration, even if not so enshrined in the Constitution, is still justified under the police power of the state. So I computed it in my calculator. The half of the coverage of page 27 to 251 is page 112, 112. Let's continue. The omission to expressly provide for compulsory arbitration in the 1987 Constitution should be construed to stress the importance and significance ascribed by the framers thereof to voluntary modes of settling disputes and collective bargaining. Compulsory arbitration, even if not so enshrined in the Constitution, is still justified under the police power of the state. Compulsory arbitration under the Labor Code is principally vested with labor arbiters. Under the Labor Code, the authority to conduct compulsory arbitration is principally vested with labor arbiters. They are possessed of the original and exclusive jurisdiction to hear and decide the cases enumerated in Article 217 thereof. However, with the advent of RA number 6715 on March 21, 1989, certain cases over which labor arbiters have original and exclusive jurisdiction may also be taken cognizance of by the voluntary arbitrators, who shall have original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the CBA, and those arising from the interpretation or enforcement of company personnel policies, or over the voluntary arbitrator or panel of voluntary arbitrators by virtue of an agreement of the parties to a controversy may also hear and decide all other labor disputes, including unfair labor practices and bargaining deadlocks. A similar grant of authority to voluntary arbitrators of said power vested upon labor arbiters strengthens further the resolve and intent of the Constitution. the law to promote voluntary modes of resolving labor disputes instead of compulsory arbitration to give impetus to these limitations abound in the law on the power of the labor arbiters or the NLRC to hear and decide certain cases. For instance, although cases arising from the interpretation or implementation of CBAs and those arising from the interpretation or enforcement of company personnel policies may have been properly filed with the labor arbiters under the all-embracing jurisdictional provision of Article 224 of the Labor Code, the law requires that the same be disposed of by the labor arbiters through no other manner except by referring them to the grievance machinery and voluntary arbitration as may be provided in said agreements. And in case of conflict in jurisdiction, the law explicitly provides that the NLRC, its regional offices, and the regional directors of the Department of Labor and Employment, or the DOLE, are not allowed to entertain disputes, grievances, or matters falling under the exclusive and original jurisdiction of the voluntary arbitrator or panel of voluntary arbitrators, and are required to immediately dispose and refer the same to the grievance machinery or voluntary arbitration provided in the CBI. Number 5. Exercise by NLRC of its original jurisdiction constitutes compulsory arbitration. The NLRC, in the exercise of its original jurisdiction, has also the authority to conduct compulsory arbitration in certain specified cases. Hence, the NLRC is said to engage in compulsory arbitration when it hears and decides petitions for injunction and national interest cases certified to it for compulsory arbitration by the DOLE Secretary pursuant to Article 278G, 263G of the Labor Code in any event because of the significance and primacy accorded by the Constitutional Labor Code to voluntary arbitration. It is mandated that before any stage of the compulsory arbitration process before the NLRC, the parties may still opt to submit their dispute to voluntary arbitration exercised by NLRC or its appellate jurisdiction not in the nature of compulsory arbitration. As earlier pointed out, it is the labor arbiter who is principally clothed with the authority to conduct compulsory arbitration in cases involving labor disputes falling under Article 224, 217 of the Labor Code. On appeal, the NLRC merely reviews the labor arbiter's decision, or as an appellate body, it is not generally a trier of facts. Hence, the exercise by the NLRC of its appellate jurisdiction cannot be considered as part of the compulsory arbitration process. When a labor arbiter renders his decision, compulsory arbitration is deemed terminated because with the issuance of his decision, the hearing and determination of the issues in a case are terminated. Thus, an appeal instituted from the decision of the labor arbiter is not deemed part of the arbitration proceedings, since the NLRC's act is merely confined to the review of the decision of the labor arbiter to determine any possible error in his findings of fact or law. The phrase pending resolution of the case or by arbitration refers solely to the proceedings before the labor arbiter. The NLRC does not normally conduct the same hearings and proceedings conducted by the labor arbiter, which by their nature constitute compulsory arbitration. Note that voluntary arbitration is extensively discussed in the notes and comments on Article 274. Saklaw pa siya ng book na to. Roman number 3, fundamental basis for exercise of jurisdiction. Number 1, existence of employer-employee relationship. The basis for the exercise of jurisdiction by labor arbiters, the NLRC, and all other labor agencies. Existence of employer-employee relationship, a prerequisite for exercising jurisdiction. The existence of employer-employee relationship between the parties litigants is a prerequisite for the exercise of jurisdiction over labor disputes by the labor arbiters, the NLRC, and the other labor agencies, a single unifying element that runs through the cases. and disputes falling under the jurisdiction of the labor arbiters is that all the enumerated cases and disputes under Article 224 arise out of or are in connection with an employer-employee relationship or some aspect or incident of such relationship. Thus, the jurisdiction of labor arbiters and the NLRC under Article 224 is limited to disputes arising from the employer-employee relationship, which can be resolved in reference to the labor code or other labor statutes or the CBAs, for as long as the principal relief is to be granted under labor legislation or a collective bargaining agreement. The case generally falls within the exclusive jurisdiction of the labor arbiters and the NLRC, even though a claim for damages might be asserted as an incident to such claim. If no such relationship exists between the parties to a suit, then the jurisdiction over the same properly lies with the regular courts. Ay. Water break. Tubig kayo dyan, guys. Ay. So far, I can read. Nagbabasa lang ako pero hindi ko pa siya masyado naintindihan. So I have to get my mood up. Aqua Plus. It was given to me by my mother. The Aqua Plus. So now let's continue. Where are we? We are here. But where are we in this reading? So I'm guessing in B. B. Requirement of employer-employee relationship jurisdictional. In the case of Attorney Andrea Uy versus Bueno, it was held that this requirement of employer-employee relationship is jurisdictional in order for the provisions of the labor code to apply. Letter C. The cause of action must arise from the employer-employee relationship, even if there is employer-employee relationship. If the cause of action did not arise out of or was not incurred in connection with the employer-employee relationship, labor arbiters may have no jurisdiction thereover. This is so because not every dispute between an employer and employee involves matters that only the labor arbiters and the NLRC can resolve. In the exercise of the adjudicatory or quasi-judicial powers, actions between employers and employees where the employer-employee relationship is merely incidental is within the exclusive original jurisdiction of the regular courts. Number 2. Determination of the existence of employer-employee relationship, not the sole and exclusive domain of labor arbiters and NLRC. An exemption is explicitly provided under Article 224, 217. Thus, 6. Exempt claims for employees' compensation, Social Security, Medicare, and maternity benefits. All other claims arising from employer-employee relations, including those of persons in domestic or household service involving an amount exceeding 5,000 pesos, regardless of whether accompanied with a claim for reinstatement. This simply means that the monetary claims for employees' compensation, Social Security, field health benefits, and maternity benefits do not fall under the jurisdiction of the labor arbiters because they are cognizable by other agencies of government such as the Social Security Commission in the case of employees' compensation, Social Security and maternity benefits, or the Philippine Health Insurance Corporation in the case of field health benefits. It is thus clear from the aforequoted exception provision that the question of determining the existence of employer-employee relationship in relation to said matters is not within the exclusive jurisdiction of the labor arbiters and the NLRC. In the Republic of the Philippines versus Asia Pro Cooperative, involving the issue of coverage of owner members of respondent cooperative under the Social Security system, the rule was pronounced that it is not only the labor arbiters and the NLRC who or which have the exclusive jurisdiction to determine the existence of the employer-employee relationship, but the SSC as well. Thus, as an incident to the issue of compulsory coverage, the SSC may inquire into the presence or absence of an employer-employee relationship without need of waiting for a prior pronouncement or submitting the issue to the NLRC for prior determination, since both the SSC and the NLRC are independent bodies and their jurisdictions are well defined by the separate statutes creating them. Petitioner SSC has the authority to inquire into the relationship existing between the worker and the person or entity to whom he renders service to determine if employment indeed is one that is accepted by the Social Security Law of 1997 from compulsory coverage. Similarly, according to the 2012 NBank resolution in People's Broadcasting Service, Bombo Radio Philippines INC versus the Secretary of the Department of Labor and Employment, the determination by the DOLE Regional Director and the DOLE Secretary of the existence of employer-employee relationship in the exercise of the inquisitorial and enforcement powers under Article 128B of the Labor Code is to the exclusion of the labor arbiters in the NLRC. This would eliminate the prospect of competing conclusions between the DOLE and the NLRC. So, this parang nag-aaway pala yung DOLE and NLRC kung sino yung merong authority. It's what yun yung nandito sa mind ko while I'm reading this. So let's continue. Earlier in 2012, based on this ruling, Superior Packaging Corporation versus Palagsay categorically declared that the DOLE clearly acted within its authority when it determined the existence of an employer-employee relationship between the petitioner and respondents, as it falls within the purview of its visitorial enforcement power under Article 128B of the Labor Code. In the same vein, it is well recognized that Med arbiters of the Bureau of Labor Relations are possessed of the same power to make determination on the existence of employer-employee relationship. It is an absurdity to suggest otherwise. Thus, once the Med arbiter has made a determination as to the existence of such a relationship, he then can decide the certification election case, as the authority to determine such relationship is necessary and indispensable in the exercise of jurisdiction by the Med arbiter over certification election cases. His finding thereon may only be reviewed and reversed by the DOLE Secretary who exercises appellate jurisdiction under Article 272 of the Labor Code of the Philippines. Hence, as held in M.Y. San Biscuits INC versus Laguesma, when as in this case, Secretary General of DOLE rendered a resolution dated December 15, 1989 reversing the order of the Med arbiter dated August 25, 1989 by declaring the existence of an employer-employee relationship between the parties. Such finding cannot be rendered nugatory by a contrary finding of the labor arbiter in the separate dispute for money claims between the same parties. It is absurd to suggest that the Med arbiter and Secretary of Labor cannot make their own independent findings as to the existence of such relationship and must have the two rely and wait for such a determination by the labor arbiter and LRC in a separate proceeding. For them, given a situation where there is no separate complaint filed with the labor arbiter, the Med arbiter and or the Secretary of Labor can never decide the certification election case or any labor management dispute properly brought before them, as they have no authority to determine the existence of an employer-employee relationship. Such a proposition is, to say the least, anomalous. Correctly, indeed, the Secretary of Labor denied the prayer in the manifestation of petitioner to await the resolution of the NLRC as to the existence of such employer-employee relationship. Number 3. In the case of OFW's existence of employer-employee relationship not required in order for labor arbiter to acquire jurisdiction thereover. A. Grant of jurisdiction even absent the employee employment relationship, the case of Santiago versus CF Sharp Crew Management Inc. presents a unique situation where the core issue presented was whether the labor arbitrator has jurisdiction to take cognizance of the complaint for illegal dismissal damages and attorney's fees filed by a petitioner who was not deployed overseas despite the signing of a POEA approved employment contract. It was ruled here that despite the absence of an employer-employee relationship between petitioner and respondent, the NLRC has jurisdiction over petitioner's complaint. This is so because the jurisdiction of labor arbitrators is not limited to claims arising from employer-employee relationships per Section 10 of RA number 8042. A distinction was further made in this case between perfection of an employment contract and the commencement of the employer-employee relationship. The distinction acquires added significance in cases involving seafarers in the light of the provision of Section 2, the standard terms and conditions governing the employment of Filipino seafarers on board ocean-going vessels, which states that the employment contract between the employer and the seafarer shall commence upon actual departure of the seafarer from the airport or seaport in the point of hire and with a POEA approved contract. It shall be effective until the seafarer's date of arrival at the point of hire upon termination of his employment pursuant to Section 18 of this contract. Thus, considering that petitioner in Santiago was not able to depart from the airport or seaport at the point of hire, the employment contract did not commence to be effective, and so employer-employee relationship was created between the parties. However, a distinction must be made between the perfection of the employment contract and the commencement of the employer-employee relationship. The perfection of the contract, which in this case coincided with the date of execution thereof, occurred when petitioner and respondent agreed on the object and the cause as well as the rest of the terms and conditions set forth therein. The commencement of the employer-employee relationship would have taken place and petitioner been actually deployed from the point of hire. Thus, even before the start of any employer-employee relationship, contemporaneous with the perfection of the employment contract was the birth of certain rights and obligations, the breach of which may give rise to a cause of action against the errant party. Hence, if the reverse had happened, that is, the seafarer failed or refused to be deployed as agreed upon, he would have been held liable for damages. Consequently, respondent in Santiago was held liable to pay petitioner actual and compensatory damages of $4,635 in the form of the loss of 9 months worth of salary as provided in the contract. Respondent's act of preventing petitioner from departing the port of Manila and boarding MSV Seaspread constitutes a breach of contract, giving rise to petitioner's cause of action. Respondent unilaterally and unreasonably renege on his obligation to deploy petitioner and must therefore answer for the actual damages he suffered. The above-mentioned distinction made in Santiago was similarly cited in Pratt Maritime Corporation versus Fontoniel, where it was ruled that while respondent seafarer cannot be deemed as having been illegally dismissed, considering that the employer-employee relationship was not yet commenced, nevertheless, petitioner's act of preventing respondent from complying with his contract of employment constitutes breach of contract, for which petitioner company is liable for actual damages to respondent for the loss of 1 year salaries provided in the contract. Additionally, respondent was awarded moral damages in the amount of 30,000 pesos, exemplary damages 50,000 pesos, and 10% of the all recoverable amounts as attorney's fees. Letter B. Labor arbitrators have jurisdiction even if case is filed by the heirs of the OFW. Petitioners in Medline Management IC versus Roslinda. claimed that the labor arbiter has no jurisdiction to hear the case or want of employer-employer relationship between the parties because respondents who filed the complaint are the wife and son of Juliano Rosalinda, the deceased R.W. Declaring this position of petitioners as devoid of merit, the High Court pointed that petitioners have not taken into consideration that respondents are the heirs of Juliano Rosalinda, as they have the personality to file the claim for death compensation, reimbursement of medical expenses, damages, and attorney's fees before the labor arbiter of the NLRC as the parties claiming benefits for the death of a seafarer. They can file a case and the labor arbiter is provided for under Section 28 of the POEA Standard Employment Contract, which clearly provides that the NLRC shall have original and exclusive jurisdiction over any and all disputes or controversies arising out of or by virtue of the POEA Sec. Filing a complaint for payment of death compensation, reimbursement of medical expenses, damage and attorney's fees before the labor arbiter of the NLRC, respondents are actually enforcing their entitlement to the above provision of the contract of Juliano with petitioners. They are the real parties in interest as they stand to be benefited or injured by the judgment in this case, or the parties entitled to the appeals of the case. Reasonable causal connection rule. Number 4. A. Application of rule to determine proper jurisdiction. In certain cases, the determination of whether a claim or cause of action arose from employer-employee relationship presents a difficult complication. While the Supreme Court has upheld the present trend to refer worker-employer controversies to labor courts in light of the provision of Article 224, it has also recognized that not all claims involving employees can be resolved solely by the labor courts, specifically when the law provides otherwise. It is for this reason that jurisprudence has developed and formulated the reasonable causal connection rule to ascertain whether a claim or cause of action asserted has a reasonable causal connection to the employer-employee if in the affirmative the same falls within the jurisdiction of the labor arbiter or other labor courts. Otherwise, in the absence of such nexus, it is the regular courts that have jurisdiction. As early as the 1983 case of Singapore Airlines Limited versus Panyo, it was pronounced that not all disputes between the employer and his employee fall within the jurisdiction of the labor tribunals. In this case, it was ruled that abandonment of work per se and the manner and consequent effects of such abandonment were differentiated in that the first is a labor case, while the second is a civil law case. Cases decided under earlier versions of Article 224 were consistent in that intrinsically civil disputes, even if these involved an employer and his employee, are recognizable by the regular courts. For instance, in Medina versus Honorable Castro Bartolome, involving a civil complaint for damages against the employer for slanderous remarks made against the plaintiffs, the regular court's jurisdiction was upheld after finding that the plaintiffs did not allege any unfair labor practice, their complaint being a simple action for damages for tortious acts allegedly committed by the defendants. In Molabi Sales, INC vs. Honorable Laron, it was held that the claim of the plaintiff against its sales manager for payment of certain accounts and cash advances were properly cognizable by the regular courts, because although a controversy is between an employer and an employee, the labor arbiters have no jurisdiction if the labor code is not involved. Letter B. Application of the reasonable causal connection rule to money claims. The application of the reasonable causal connection rule to money claims cases was expounded in San Miguel Corporation versus NLRC, in what, while paragraph 3 of Article 224 refers to all money claims of workers, it is not necessarily to suppose that the entire universe of money claims that might be asserted by workers against their employers has been absorbed into the original and exclusive jurisdiction of labor arbiters. In the first place, paragraph 3 should be read not in isolation form but rather within the context formed by paragraph 1, paragraph 2, paragraph 4, and paragraph 5 thereof, it is evident that there is a unifying element which runs through paragraphs 1 to 5, and that is that they all refer to cases or disputes arising out of or in connection with employer-employee relationship. This is, in other words, a situation where the rule of nocitur aesocies may be usefully invoked to clarify the scope of paragraph 3 and any other paragraph of Article 217 of the Labor Code as amended. This conclusion was reached from an examination of the terms themselves. Article 224 as last amended by BP Bilang 227, lately by RA number 6715, and even though earlier versions of Article 224 of the Labor Code expressly brought within the jurisdiction of the labor arbiters and the NLRC cases, National Labor Relations Commission, cases arising from employer-employee relations, which clause was not expressly carried over in Printers Inc. In Article 224 as it exists, Printers Inc. Employer-employee relations, which clause was not expressly carried over in Printers Inc. in Article 224 as it exists today, for it cannot be presumed that money claims of workers which do not arise out of or in connection with their employer-employee relationship and which would therefore fall within the general jurisdiction of regular courts of justice were intended by the legislative authority to be taken away from the jurisdiction of the courts lodged with labor arbiters on an exclusive basis. The court therefore believes and so holds that the money claims of workers referred to in paragraph 3 of Article 224 embraces money claims which arise out of or in connection with employer-employee relationship or some aspect or incident of some relationship. Put a little differently, the money claims of workers which now fall within the original exclusive jurisdiction of labor arbiters are those money claims which have some reasonable and causal connection with the employer-employee relationship. Paragraph C. Application of the reasonable causal connection rule to claims for damages. It was declared in Daiichi Electronics Manufacturing Corporation versus Honorable Villarama that claims for damages under paragraph 4 of Article 224 to be cognizable by the labor arbiter must have a reasonable causal connection with any of the claims provided for in that article. Only if there is such connection with the other claims can the claim for damages be considered as arising from employer-employee relations. The reasonable causal connection rule was also applied in Pepsi Cola distribution. Reasonable causal connection rule. Claims for damages. Also applied in Pepsi Cola Distributors of the Philippines INC versus Galyang, where it was held that an action filed by the employees against an employer for damages for the latter's malicious filing or a criminal complaint for falsification of private documents against them comes under the jurisdiction of the regular courts. The same rule was applied in Portillo versus Rudolph Lates IAC, where it was pronounced that the reasonable causal connection with the employer-employee relationship is required not only in employees' money claims against the employer, but is likewise a condition when the claimant is the employer. The claim of respondent Rudolph Lates INC against petitioner Portillo for liquidated damages does not arise from employer-employee relationship, nor is there any reasonable connection with such relationship of such claim. Hence, it falls under the civil laws and not under the labor code. Reasonable causal connection. Reasonable causal connection. The claim of respondent Rudolph Lates. liquidated damages. Reasonable causal connection. Application of the reasonable causal connection rule. Quasi-delict or tort cases. The same San Miguel case was cited in Ocheda versus CA, where it was held that when the cause of action is based on a quasi-delict or tort which has no reasonable causal connection with any of the claims provided for in Article 224, jurisdiction over the action is with the regular courts. Similar holding was made in Evelyn Tolosa versus NLRC, where it was held that since the action for damages filed by petitioner for the death of her husband, Captain Benilio Tolosa, is in the nature of quasi-delict or tort, the labor arbiter has no jurisdiction. At the regular court lately, the same rules has been reiterated in Indophil Textile Bioscience versus Engineer Salvador Adviento. Let's have a break, guys. Roman numeral number 4. Basic principles on jurisdiction over labor cases. Number 1. Principles applicable to labor proceedings. Letter A. Law confers jurisdiction. It is a well-settled rule that jurisdiction is conferred only by the Constitution or by law. It cannot be fixed by the will of the parties. It cannot be acquired through enlarged or diminished by any act or omission of the parties. It is likewise a settled rule that jurisdiction is determined by the statute in force at the time of the commencement of the action, and that once again acquired, it continues until the case is finally terminated. B. Material allegations in the complaint determine jurisdiction. The rule is that the nature of an action and its subject matter, as well as the court or agency of the government that has jurisdiction over it, are determined by the material allegations of the complaint in relation to the law involved in the character of the reliefs prayed for. C. Jurisdiction not dependent on the validity of the allegations, nor on the defenses asserted in the answer or invoked in the motion to dismiss. Time check, it's 3:10 in the morning, May 5, 2022. So in C, this rule that the determination of jurisdiction is based on the allegations of the complaint holds true irrespective of whether or not the plaintiff is entitled to recover upon the claim asserted therein, which is a matter resolved only after any result of a trial. Neither can jurisdiction of a court be made to depend upon the defenses made by a defendant in his answer or motion to dismiss. If such were the rule, the question of jurisdiction would depend almost entirely upon the defendant. Letter D. Prayer or demand for relief does not determine jurisdiction. A prayer or demand for relief is not part of the cause of action, nor does it enlarge the cause of action, stated, or change the legal effect of that is alleged. In determining which body has jurisdiction over a case, the better policy is to consider not only the status or relationship of the parties, but also the nature of the action that is the subject of the controversy. Letter E. Estoppel does not confer jurisdiction. There are divergent jurisprudential doctrines touching on this issue. On the one hand are a plethora of cases, all adhering to the doctrine that a party's active participation in the actual proceedings before a court without jurisdiction will stop such party from assailing the lack of jurisdiction. On the other hand, a long line of cases are one in dealing the jurisdiction is conferred by law and lack of jurisdiction may be questioned at any time, even on appeal. The notion that the defense of lack of jurisdiction may be waived by estoppel on the party invoking the same most prominently emerged in Tijam versus Sibong Hanoi. However, Tijam stands as an exception rather than a general rule because the party invoking the lack of jurisdiction did so only after 15 years and at a stage when the proceeding had already been elevated to the CA. The rule in Luzon versus NLRC elucidated a clear rule as to when jurisdiction estoppel applies and when it does not. Lack of jurisdiction over the subject matter of the suit is yet another Lawson versus NLRC. Whenever it appears that the court has no jurisdiction over the subject matter, the action shall be dismissed, and this defense may be interposed at any time, during appeal or even after final judgment. Such is understandable as this kind of jurisdiction is conferred by law and not within the courts, let alone the parties to themselves determine or conveniently set aside. Consequently, applying laws on Manor Motors D. and De Rossi in the 2005 case, Metro Media Times Corporation versus Pastorin, it was ruled that since the labor arbitrator assumed jurisdiction when he should not over an issue which is properly recognizable by the grievance machinery, petitioner is not stopped from assailing. Petitioner is not stopped. Labor arbiter. Assailing from the jurisdiction of the labor arbiter for the NLRC on appeal in line with the cases cited above and applying the general rule that estoppel does not confer jurisdiction. Splitting of cause of action engendering multiplicity of actions. An illegally dismissed employee cannot be allowed to sue in two fora: one, before the labor arbiter for reinstatement and back wages or separation pay on the basis of the theory that his dismissal was illegal, and two, before the regular court for recovery of moral and other damages on the basis of the theory that the manner of his dismissal was tortious and injurious. This is a splitting of cause of action engendering multiplicity of actions. When an employee therefore constitutes a case before the labor arbiter, he should include all his claims for reliefs. Piecemeal prosecution of claims cannot be countenanced. 3G. Rule in case of conflict jurisdiction between labor court and regular court. The demarcation line between the jurisdiction of regular courts and labor courts over cases involving workers and their employers has always been the subject of dispute. The Supreme Court has recognized that not all claims involving workers and their employers can be resolved solely by the labor courts. However, it has also been admonished that the present trend is to refer worker-employer controversies to labor courts unless unmistakably provided by the law to be otherwise. Number 2. Labor disputes not subject to barangay conciliation. Labor cases are not subject to the conciliation proceedings prescribed under PD number 1508, requiring the submission of disputes before the barangay lupong tagapayapa prior to their filing with the court or other government offices. The decree's intention, as reflected in the 3 whereas clauses therein, is to make its provisions applicable only to cases cognizable by courts of justice and not to those falling within the jurisdiction of the NLRC or labor arbiters. Requiring conciliation of labor disputes before the barangay courts would defeat the very salutary purposes of the law instead of simplifying labor proceedings. Powers of labor arbiters. Various powers of the labor arbiters based on the law, its implementing rules, as well as jurisprudence. The following powers of labor arbiters deserve to be cited and discussed therein. Labor power. Injunction power. B. A is injunction power. And C. A is injunction power. B. Contempt power. And C. Power to conduct ocular inspection. Injunction power of labor arbiters. Under the 1990 New Rules of Procedure of the NLRC, labor arbiters are expressly granted the power to issue injunction in ordinary cases. Thus, it is provided therein that the foregoing ancillary power to issue preliminary injunction of restraining order may be exercised by the labor arbiters only as an incident to the cases pending before them in order to preserve the rights of the parties during the pendency of the case, but excluding labor disputes involving strike or lockout. This provision in the 1990 NLRC rules, however, is no longer found in its 2000 to 2012 2011 versions. This deletion is correct, since Article 225E grants injunctive power only to the Commission, which obviously refers to the NLRC's various divisions and not to the labor arbiters. The Supreme Court in the 2012 case of Lam III versus Mayor confirmed the foregoing discussion on the lack of injunctive power of labor arbiters. It noted that while in the 1990 NLRC rules of procedure, the labor arbiter has in proper cases the authority to issue writs of preliminary injunction and or restraining orders. Nevertheless, under its 2005 rules of procedure, the labor arbiters no longer had the authority to issue the same. Only the NLRC, through its divisions, may issue writs of preliminary injunction and temporary restraining orders. The role of the labor arbiters with regard to the issuance of writs of preliminary injunctions and or writ of preliminary injunction was limited to reception of evidence as may be delegated by the NLRC. The labor arbiters thus may conduct hearings on the applicant of preliminary injunction or restraining order only in a delegated capacity. Consequently, under Article 225E to 218E and the 2011 NLRC Rules of Procedure, the reception of evidence for the application of a writ of injunction may be delegated by the Commission to any of its labor arbiters, who shall conduct such hearings in such places as he or she may determine to be accessible to the parties and their witnesses, and shall thereafter submit his or her report and recommendation to the Commission within 15 days from such delegation. Contempt power of labor arbiters. The labor arbiters, pursuant to Article 225D, 218D, may cite any person for direct or indirect contempt and impose the appropriate penalty under certain specified grounds. Note: for more comprehensive discussion, please read lots of cases. Number 4, power to conduct ocular inspections. Under Article 226 to 219 of the Labor Code, the labor arbiters or their duly authorized representatives have the power to conduct ocular inspections at any time during working hours on any establishment, building, ship or vessel, place or premises, including any work material, implement, machinery, appliance, or any object therein, and ask any employee, laborer, or any person, as the case may be, for any information or data concerning any matter or question relative to the object of the investigation or petition. Okay. Number 6, kinds of jurisdiction under Article 224. Jurisdictional interplay among labor arbiters, commission, and grievance machinery and voluntary arbitration. Article 224 does not only speak of jurisdiction of labor arbiters but also of the National Labor Relations Commission. It treats of the dynamic jurisdictional interplay between the labor arbiters, the commission, and the grievance machinery and voluntary arbitrators or panel of voluntary arbitrators. Number 1, paragraph A of Article 224 describes the nature of the jurisdiction of the labor arbiters in the cases falling under the original exclusive jurisdiction. Paragraph B thereof treats of the exclusive appellate jurisdiction of the Commission NLRC over all cases decided by labor arbiters, and paragraph C, number 3, thereof emphasizes the jurisdiction of the grievance machinery and voluntary arbitrators or panel of voluntary arbitrators over cases involving the interpretation or implementation of collective bargaining agreements, and those arising from the interpretation or enforcement of company personnel policies. The appellate jurisdiction of the Commission over cases arbiters is decided in Article 229. Significant distinction. Significant distinction between jurisdiction of labor arbiters and the Commission and NLRC may be readily observed that under paragraph B, Article 224, the Commission and NLRC has exclusive appellate jurisdiction. As exclusive appellate jurisdiction over all cases decided by the labor arbiters in the exercise of their original and exclusive jurisdiction. This simply means that the NLRC does not have original jurisdiction over the cases enumerated in paragraph A of Article 224, 217, that if a claim does not fall within the original jurisdiction and exclusive jurisdiction, the NLRC cannot appellate jurisdiction thereover. For instance, since under Article 224, it is the labor arbiter who has original and exclusive jurisdiction over termination disputes, the NLRC can exercise only exclusive appellate jurisdiction thereover. Significant distinction between jurisdiction of labor arbiters and voluntary arbitrators. While the cases falling under the jurisdiction of labor arbiters are expressly specified by law, therefore they cannot take cognizance of cases unless the law itself confers jurisdiction of them. The voluntary arbitrators or panel of voluntary arbitrators besides the cases specified in Article 274 and other laws can take cognizance of cases by virtue of the mutual agreement of the parties as provided in Article 275, which states that the voluntary arbitrator or panel of voluntary arbitrators, upon agreement of the parties, shall also hear and decide all other labor disputes, including unfair labor practices and bargaining deadlocks. Jurisdiction of Roman numeral number 7, jurisdiction of labor arbiters. Legal basis for exercise of jurisdiction. Laws conferring jurisdiction on labor arbiters. The following provisions grant original and exclusive jurisdiction to labor arbiters. Under the Labor Code, Article 224, Article 124, Article 128, Article 22, 233, 276, under other law, Section 10 of RA number 8042, as amended by RA number 122. B. Rundown of all cases falling under the jurisdiction of the labor arbiters. More particularly, labor arbiters have original and exclusive jurisdiction to hear and decide the following cases, involving all workers, whether agricultural or non-agricultural. Under Article 224 of the Labor Code, unfair labor practice, termination disputes, if accompanied with a claim for reinstatement, those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment, claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relations, cases from any violation of Article 279 of the Labor Code as amended, including questions involving the legality of strikes and lockouts, except claims for employees' compensation, Social Security, PhilHealth, Medicare, and maternity benefits. All other claims arising from employer-employee relations, including those of persons in domestic or household service involving an amount exceeding 5,000 pesos, whether or not accompanied with a claim or for reinstatement. Under Article 124 of the Labor Code as amended by RA number 6, disputes involving legislated wages, wage increases, and wage distortion in unorganized establishments were not voluntarily settled by the parties. 727. 0. Contested cases. Exception clause in Article 128B and Article 233. The Labor Code, enforcement of compromise agreements when there is non-compliance by any of the parties pursuant to Article 233 of the Labor Code. In the Article 276 of the Labor Code, issuance of writ of execution to enforce decisions of voluntary arbitrators or panel of voluntary arbitrators in case of their absence or incapacity for any reason. Under Section 10 of RA number 8042, submitted by RA number 10022, money claims arising out of employer-employee relations or by virtue of any law or contract. Money claims arising out of employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for death and disability benefits and for actual moral exemplary and other forms of damages are provided in RA number 8042. C. Conferment. C. Conferment of jurisdiction under the NLRC rules. Under the 2011 NLRC Rules of Procedure, it is provided that the labor arbiter may also exercise jurisdiction over other cases as may be provided by law. However, as to what these cases are, the rules do not specify. Obviously, this provision refers to possible grant of jurisdiction to labor arbiters as may be provided in subsequent laws. D. Conferment of jurisdiction by mutual agreement of the parties, when labor arbiters may act as voluntary arbitrators. Jurisprudentially, there is recognition that labor arbiters may act as voluntary arbitrators when parties to a labor case both mutually agree to submit their issues to labor arbiters for voluntary arbitration. The 1998 case of Manila Central Line Corporation best illustrates this situation. This case arose out of the CBA deadlock between petitioner and private respondent, Manila Central Line Free Workers Union National Federation of Labor. The parties' CBA had expired on March 15, 1989. As the parties failed to reach a new agreement, private respondent sought the aid of the NCMB on October 30, 1989, but the deadlock remained unresolved. On February 9, 1990, private respondent filed a petition for compulsory arbitration with the labor arbiter of the arbitration branch of the NLRC. At the initial hearing before the labor arbiter, the parties declared that conciliation efforts before the NCMB had terminated. It was they decided to submit the case for compulsory arbitration. Accordingly, they were required to submit their position papers and proposals, which they did, and in which they indicated portions of their respective proposals to which they agreed, leaving the rest for arbitration. On September 28, 1990, the labor arbiter rendered a decision embodying provisions for a new CBA. Petitioner appealed, and its appeal was denied by the NLRC. Before the Supreme Court, petitioner contended that the NLRC erred in upholding the jurisdiction of the labor arbiter. This despite the fact that it agreed with the union to submit their dispute to the labor arbiter for arbitration. Petitioner argued that the policy of the law now is to encourage resort to conciliation and voluntary arbitration, as Article 26E, 250E the Labor Code provides. The Supreme Court ruled that indeed the Labor Code formerly provided that if the parties in collective bargaining fail to reach an agreement, the Bureau of Labor Relations BLR should call them to conciliation meetings, and if its efforts were not successful, certify the disputes to a labor arbiter for compulsory arbitration. But this was changed by RA number 6715, which took effect on March 21, 1989. Article 261E, 250E now provides that if effects of conciliation fail, the NCMB shall encourage the parties to submit their case to a voluntary arbitrator with specific reference to cases involving deadlocks in collective bargaining. Article 275 provides that the voluntary arbitrator or panel of voluntary arbitrators, upon agreement of the parties, shall also hear and decide all other labor disputes, including unfair labor practices and bargaining deadlocks. This is what the parties did in this, including unfair. In this case, after the NCMB failed to resolve the bargaining deadlock between the parties, the union filed a petition for compulsory arbitration in the arbitration branch of the NLRC. Petitioner joined the petition, and the case was submitted for decision. Although the union's petition was for compulsory arbitration, the subsequent agreement of petitioner to submit the matter for arbitration in effect made the arbitration a voluntary one. The essence of voluntary arbitration, after all, is that it is by agreement of the parties rather than compulsion of law that a matter is submitted for arbitration. It does not matter that the person chosen as arbitrator is a labor arbiter who, under Article 223, is charged with compulsory arbitration of certain labor cases. There is nothing in the law that prohibits these labor arbiters from also acting as voluntary arbitrators, as long as the parties agree to have him hear and decide their dispute. Moreover, petitioner must be deemed to be stopped from questioning the authority of the labor arbiter to act as voluntary arbitrator and render a decision in this case. Petitioner agreed together with the union to refer their dispute for arbitration to him. It was only after the decision was rendered that petitioner raised the question of lack of jurisdiction. Even then, petitioner did so only for the first time in a supplemental memorandum of appeal to the NLRC. As the NLRC held, it was too late in the day for petitioner to do this. It was further pronounced in this case that indeed it is inconsistent for petitioner to contend, on the other hand, that this case should have been resolved through voluntary arbitration, and on the other, to follow the procedure for compulsory arbitration and appealing the decision of the labor arbiter to the NLRC, and subsequently questioning the latter's decision in Luzon Development Bank versus Luzon Development Bank Employees Association. This case, considered as a special civil action for certiorari to set aside the decision of a voluntary arbitrator, should have been referred as a matter of policy to the Court of Appeals. However, it was not evident in the beginning from a cursory consideration of the pleadings that what actually took place in the labor agency was a proceeding for voluntary arbitration. Accordingly, so as not to delay in the disposition of this case, the same should be retained and decided on the merits. Nature of jurisdiction. The jurisdiction conferred by Article 224 to labor arbiters is both original and exclusive. Meaning, no other officers or tribunals can take cognizance of or hear or decide any of the cases therein enumerated, except those that this article itself has excluded by virtue of the express exclusionary clause found in the opening paragraph thereof. Covered employees, number 3. Number 3, covered employees. Generally, all workers are covered by the jurisdiction of labor arbiters. Labor arbiters generally have original and exclusive jurisdiction to hear and decide all cases involving all workers, whether agricultural or non-agricultural. As well as claims of overseas of Filipino workers provided by law. Letter B. Transfer of jurisdiction over agricultural workers from CAR to labor arbiters. The jurisdiction over controversies involving agricultural workers had been transferred from the Court of Agrarian Relations to the labor arbiters under the Labor Code. Just the same, existence of employer-employee relations should still be established, otherwise the labor arbiters have no jurisdiction thereover. Exceptions to the exercise of original and exclusive jurisdiction of labor arbiters. That Article 224 admits of certain exceptions as far as the exercise of jurisdiction of the labor arbiters is concerned is clear from the opening sentence of Article 224, which states, except as otherwise provided under this code, appropriate. That Article 224 admits of certain exceptions as far as exemption. Ink. Except as otherwise provided under this code. Under this code. Appropriate to be cited exceptions are the following. When the secretary that Article 224 admits of certain exceptions as far as the exercise of jurisdiction of labor arbiters is concerned is the opening sentence of Article 224A states that except as otherwise provided under this code, appropriate to be cited as exceptions are the following. When the Secretary of Labor and Employment Sole or the President exercises his power under Article 278G of the Labor Code to assume jurisdiction over national interest cases and decide them themselves. When the NLRC exercises its power of compulsory arbitration, NLRC power over national interest cases that are certified to it by the SOLE, pursuant to the exercise by the latter of his certification power under the same Article 278. When cases arise from interpretation or implementation of collective bargaining agreements and from the interpretation or enforcement of company personnel policies, which shall be disposed of by the labor arbiter by referring the same to grievance machinery and voluntary arbitration as may be provided by in said agreements. When the parties mutually agree to submit the case to the grievance machinery and voluntary arbitration before a voluntary arbitrator or panel of voluntary arbitrators who under Articles 274 and 275 of the Labor Code are also possessed of original and exclusive jurisdiction to hear and decide cases mutually submitted to them by the parties for arbitration. and adjudication. The labor arbiters do not have jurisdiction over the cases mentioned above, which are taken cognizance of by said other labor officials or tribunals under separate specific provisions of the Labor Code. Numbers 1 and 2 above concern the exercise numbers 1 and 2 concern the exercise or by the Dole Secretary of his extraordinary option Dole Secretary extraordinary option to either assume jurisdiction over labor dispute affecting industries indispensable to the national interest and decide it himself or certified it to the NLRC for compulsory arbitration, in which event it will be the NLRC that will hear decide it in both instances, and all issues related thereto, over which the labor arbiters or other labor authorities may have jurisdiction over, all deemed subsumed or absorbed in the assumed or certified case. As far as numbers 3 and 4 above are concerned, the last paragraph of Article 224 is very clear that cases arising from the interpretation or implementation of collective bargaining agreements and those arising from the interpretation or enforcement of company personal policies shall be disposed of by the arbiter by referring the same to the grievance machinery, and voluntary arbitration as may be provided in said agreements. By so providing, Article 224 acknowledge in no uncertain terms the jurisdiction of the grievance machinery under Article 273 and that of the voluntary arbitrator or panel of voluntary arbitrators under Article 27 for all of these issues. Cases arising from the interpretation or implementation of collective bargaining agreements. Cases arising from the interpretation or implementation of collective bargaining agreements and those arising from the interpretation or enforcement of company personal policies shall be disposed of by the labor arbiter by referring the same to the grievance machinery and voluntary arbitration as may be provided in said agreements. Let's have a break. Next topic is jurisdiction over unfair labor practice cases. So I'm back. Roman numeral number 8, jurisdiction over unfair labor practice cases. Jurisdictional basis by express provision of Article 224, labor arbiters have original and exclusive jurisdiction to hear and decide unfair labor practice ULP cases. Unfair labor practice ULP acts among the cases cognizable by the labor arbiters. Resolution of ULP cases is required to be given utmost priority. They are mandated to resolve such cases within 30 calendar days from the time they are submitted for decision. Limitations on exercise of jurisdiction over ULP. A. Limitations on jurisdiction of labor arbiters in ULP cases under Article 258. Under Article 258, the ULP Act has two aspects, the civil and criminal aspects. The labor arbiters have jurisdiction only on its civil aspect, which may include claims for actual, moral, exemplary, and other forms of damages, attorney's fees, and other affirmative reliefs It must be noted that recovery of civil liability in the administrative proceeding before the labor arbiter bars recovery under the civil code. Labor arbiters have no jurisdiction over the criminal aspect of ULP. The criminal aspect is properly cognizable by the regular courts. However, it is a prerequisite that no criminal prosecution for ULP may be instituted without a final judgment finding that ULP was committed having been first obtained in the administrative proceedings before the labor arbiter. During the pendency of the administrative proceedings before the labor arbiter, the running of the prospective period for the criminal offense is interrupted. The final judgment in the administrative proceedings before the labor arbiter will neither be binding in the criminal case nor will it be considered as evidence of guilt of the accused in the criminal case. Its sole probative value is to prove compliance with the said prerequisite before the corresponding criminal action may be instituted in the regular courts. By B. Other limitations exercised by the President or the Secretary of Powers granted under Articles 278 and 279 of the Labor Code. And the President of the Philippines or his alter ego, the Dole Secretary, exercises the powers vested in them under Articles 278 and 279 of the Labor Code, the jurisdiction over the civil aspect of all cases involving ULPs, including damages, attorney's fees, and other affirmative reliefs, shall no longer be vested with the labor arbiters. The power mentioned in the third paragraph of Article 258 in relation to Articles 278 and 279 of the Labor Code, specifically paragraph of Article 278, pertains to the power of the President or the Secretary of jurisdiction. Exercise of jurisdiction by the NLRC. Although in the third paragraph of Article 258 mentions only the President and the Dole Secretary, the NLRC may also exercise the same power with the Dole Secretary in national interest cases certified to it by the Dole Secretary for compulsory arbitration pursuant to Article 278 of the Labor Code. If so certified, the NLRC has now the jurisdiction to decide all the issues in the certified case to the exclusion of the Dole Secretary or any other labor authorities. But the exercise of jurisdiction by the voluntary arbitrators under Article 275 of the Labor Code, voluntary arbitrators or panel of voluntary arbitrators are expressly granted jurisdiction to hear and decide ULPs upon mutual agreement of the parties. Such exercise of jurisdiction is to the exclusion of the labor arbiters. Jurisdiction over violations of CBA. The labor arbiter retain jurisdiction over ULP cases despite the amendments introduced by RA number 6715. There is, however, a significant change. The unqualified jurisdiction conferred upon labor arbiters prior to said amendments has been scaled down so that violations of collective bargaining agreement, except those which are gross in character, shall no longer be treated as unfair labor practice but as grievances under the collective bargaining agreement. Hence, according to the Supreme Court in Silva v. NLRC, for ULP cases to be cognizable by the labor arbiters and for the NLRC to exercise its appellate jurisdiction thereover, the allegations in the complaint should show prima facie the concurrence of two requisites, namely gross violation of the CBA. The violation pertains to the economic provisions of the CBA. It is clear, therefore, that if the violation of the CBA is not gross in character, or even if gross, if the same does not relate to the economic provisions thereof, the jurisdiction to hear and decide it is vested with the grievance machinery under Article 273, or with the voluntary arbitrators or panel of voluntary arbitrators under Article 274. Following the ruling in Silva, it was held in San Miguel Foods Inc. versus San Miguel Corporation Employees Union PTWGO that the labor arbiter has no jurisdiction to decide the issue of whether the grievance machinery was violated by the petitioner company. The grievance machinery provision in the CBA is not an economic provision, hence the second requisite for labor arbiter to exercise jurisdiction over ULP is not present. However, a different ruling was made in the San Miguel Foods case on the issue of violation of the job security provision of the CBA, specifically the seniority rule. Therein provided the union charged the employer SMFI for ULP because it has appointed less senior employees to positions at its finance department. Consequently, intentional bypassing more senior employees who are deserving of said appointment, the Supreme Court, following liberal construction of Article 274 labor code, held that the job security issue is economic in nature, since the seniority rule in the promotion of employees has bearing on salaries and benefits. Hence, it may not be seriously disputed that the aforesaid charge is a gross or flagrant violation of the seniority rule under the CBA ULP. Jurisdiction over ULP cases filed by union member against his union. The 2016 case of Alan M. Mendoza versus officers of Manila Water Employees Union is a unique case where petitioners complained for ULP. The 2016 case of Alan M. Mendoza versus officers of Manila Water Employees Union is a unique case where petitioners complained for ULP, which was lodged before the labor arbiter, was based on his two successive suspensions for 30 days, each for his first two offenses and subsequent expulsion for his third offense, all involving his non-payment of his union dues as a member of respondent's union. The labor arbiter, based on her finding that the parties failed to exhaust first all the administrative remedies before resorting to compulsory arbitration, referred back the case to the Union for the General Assembly to act on a deliberate appeal on the decision of the executive board to expel him. On petitioner's appeal, the NLRC declared the said labor arbiter's decision was null and void for being rendered without jurisdiction, and consequently dismissed petitioner's complaint on its finding that the disputes and conflict between petitioner and respondent officers of the union fall under the jurisdiction of the Bureau of Labor Relations, as these are intra-union disputes. This ruling of the NLRC was subsequently affirmed by the CA. The Supreme Court, however, disagreed and ruled that the nature of petitioner's cause of action is not that of an intra-union dispute, that the labor arbiter has jurisdiction over the charge of ULP. The reason cited is that the respondent union officers, by their act of twice suspending petitioner and subsequently expelling him from membership therewith without affording him the right to appeal under the union's constitution and bylaws, are guilty of unfair labor practices under Article 260, that is, violation of petitioner's right to self-organization, unlawful discrimination, and illegal termination of his union membership, which case falls within the original and exclusive jurisdiction of the labor arbiters in accordance with Article 224 of the Labor Code. In view of its holding that the respondents are guilty of ULP, they were all ordered to indemnify petitioner Alan M. Mendoza the amounts of 100,000 pesos as by way Of moral damages, 50,000 pesos. As exemplary damages and attorney's fees equivalent to 10% of the total award. Number 6. Jurisdiction over ULP cases initiated by a federation against its local chapter. A federation cannot initiate a ULP case before the labor arbiter against its local chapter and the employer on the ground of illegal disaffiliation. The complaint should immediately be dismissed for lack of cause of action, since the federation, being mere agent of the members of its local chapter who, in legal contemplation, are considered the principal, cannot act separately and independently from the latter, and thus lacks the legal personality to institute a complaint. In Philippine Skylanders INC versus NLRC, the Philippine Skylanders Employees Association, a local labor union affiliated with the Philippine Association of Free Labor Unions, disaffiliated from the latter, citing as my alarm clock just sounded. So let's continue. As reason of PAFLU's affiliated with the Philippine Association of Free Labor Unions, PAFLU is affiliated from the latter, citing as reason PAFLU's supposed deliberate and habitual dereliction of duty towards its members. PSEI subsequently affiliated itself with the National Congress of Workers NCW, and thereafter negotiated and entered into a CBA with petitioner company. PAFLU filed a complaint for ULP with a labor arbiter against petitioner company and its officers, as well as the elected officers of the PSEA. PAFLU, the labor arbiter, found them guilty of ULP, ordered them to pay PAFLU 150,000 pesos damages. This ruling of the labor arbiter was upheld by the NLRC. In reversing this ruling, the High Court pronounced there is a further consideration that likewise argues for the granting of the petitions. It stands unchallenged that PAFLU instituted the complaint for unfair labor practice against the wishes of workers whose interests it was supposedly protecting. The mere act of this affiliation that divest PSEA of its own personality, neither did it give PAFLU the license to act independently of the local union. Recreant to its mission, PAFLU cannot simply ignore the demands of the local chapter and decide for its welfare. PAFLU might have forgotten that as an agent it could only act in representation of and accordance with the interests of the local union. The complaint then for unfair labor practice lodged by PAFLU against PSEA, and their respective officers having been filed by a party which has no legal personality to institute the complaint should have been dismissed at the first instance for failure to state a cause of action. So we'll stop there, and my phone is already, the storage is already full. It's keep on display that the storage is full, so I'm already on page 51 of the labor code written by J.G. Chan. Joselito Guianan Chan. So we will stop from there, and hopefully we can finish. So 50 pages for 2 consecutive days. So next topic is jurisdiction over termination disputes. Roman numeral number 9. Good morning, guys.